Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Good morning. This is episode 2 of the Clean Air Act's Basics podcast. In the first episode, we discussed historic events leading up to the Clean Air Act. And today we're going to talk about two foundational elements of the Clean Air Act, the National Ambient Air Quality Standards and state implementation plans. And after we walk through how those two aspects of the Clean Air Act work, we're going to talk in depth about cross-state air pollution and how the Act uses state plans and federal and state cooperative action to address cross-state issues. I'm Matt Oakes. I moderate the series, and I've spent about 17 years as a litigator for the United States Department of Justice, working on Clean Air Act issues and other pollution control issues. And I also teach a Clean Air Act class for the University of Maryland. My guest today is Norman Rave. Norman has had an extraordinary career. He has a background as a biochemist and has degrees in biochemistry and molecular biology. He worked for the United States Department of Justice for about 2 decades, from 1998 to 2018, defending EPA regulations. And he was involved in defending aspects of almost every major Clean Air Act regulatory change in that 20-year window. He defended the Clean Power Plan, industrial boiler standards, multiple rounds of national ambient air quality standards, including the American trucking case in the Supreme Court, multiple greenhouse gas standards. Prior to his work for the Department of Justice, Norman spent a decade at Piper and Marbury, where he primarily litigated EPA RCRA rules. This morning, I actually searched the DC Circuit database for Norman Rave. I got 79 hits in just the DC Circuit, so that's a pretty impactful career. Our discussion today is going to revolve around the cross-state air pollution rule and its predecessor rule. The cross-state air pollution rule is the rule that resulted in the Supreme Court's Homer City decision. But first, I want to ask Norm, how did you start in biochemistry and end up as a litigator?
Lord, a long and somewhat rambling path. So I majored in biochemistry and molecular biology. It was one department. And back in the late 70s, I graduated from college in 78. So molecular biology in particular was a rather early field in its early days. And that's what I wanted to do. I wanted to do research. I started actually a doctoral program. But I don't know, after a couple of quarters, I felt like I needed a break, and felt like, just this treadmill of going to school, and I thought I took a leave, and then never went back. I wandered around a bit, worked, got married, worked a number of jobs doing lab testing, a lot of pollution, compliance pollutant testing in a testing lab, and other assorted jobs. And after 10, 12 years of that, I decided I needed some kind of more focus, looked into various options, and decided to go to law school because that seemed to, the last thing in the world I imagined I would end up doing is litigating, but because I was more interested in environmental issues and environmental policy issues. And so I considered master's degrees in law school. But law school seemed to offer a lot of flexibility, and new lawyers who were doing a bunch of different things. So my wife, in the meantime, actually was a real molecular biologist. She actually has a doctorate and was finishing up a postdoc. So at the time, it made sense to kind of coordinate looking for law schools and looking for her next step in her career. And so we ended up actually moving into the DC area, where I went to Georgetown for law school. And I was interested in environmental law. There weren't very many classes in it, but I did, go through the summer associate route at Piper and Marbury, which is in their relatively small but fairly active environmental law practice, and took a job there and worked there doing a lot of work for, that was the sort of period of intense rulemaking under RCRA to implement the revisions to RCRA being the hazardous waste statute that had been made in, I think, 84. There were lots of rulemakings to implement those requirements, and we represented a utility trade group. So a lot of comment writing and some litigation. And then I was ready to move on from that, and I happened to know someone who was at EDS and contacted them. They said, I got this case I would really love you to work on, and turned out to be American Trucking. And mostly because 30 some years ago, when I started at Piper and Marbury, not very many environmental lawyers, or probably lawyers of any type outside perhaps the patent field, had much of a technical background. Most people were English majors or poli-sci majors, or so just knowing the difference between a milliliter and a kilogram and a meter gave one a decided edge. And the American Trucking case, despite the fact that it's mostly known now for the non-delegation issue, actually had a lot of complicated technical issues involving the epidemiological studies, the lab work, because that was the case in which the EPA created the fine particulate matter, PM 2.5 standard, or challenged that rule. So anyway, I came over to EDS, got sort of inserted into the petition practice side of EDS's work, and spent 20 years doing lots of Clean Air Act stuff, because then at that point we were implementing the 1990 Clean Air Act amendments. So plus the Act also has requirements for periodic reviews of many of its provisions.
Great. And so I'll just clarify the EDS you've mentioned a couple of times. That's the Environmental Defense section of the Department of Justice. And I should add, and it just seems like a generally safe thing to do. Neither Norm nor I speak for the United States in this podcast.
Yes.
Norm doesn't even work for the Department of Justice anymore, and I'm not speaking on rules that I've worked to defend. But I just wanted to make that caveat. One of the things that we're doing today is talking about a couple of rules you worked on: the cross-state air pollution rule, the clean air interstate rule. But before we do that, I wanted to walk through some of the basic framework of the Clean Air Act. That's one of the primary goals of this podcast. So I wanted to walk through the basic framework of the National Ambient Air Quality Standards and talk a little bit about how the NAAQS are related to state implementation plans. There's a lot of acronyms in the Clean Air Act, more so than most anything else I've worked on. So I will try to spell out what those acronyms mean occasionally, but if you catch me doing too much acronyms, but by all means, throw up a red flag. But basically, the federal government sets air quality standards for pollutants, and states have primary responsibility for determining how to meet those standards and for regulating sources within their border. EPA, when setting the standards, sets what's called National Ambient Air Quality Standards. They're often called the NAAQS. And those NAAQS establish the maximum allowable levels of common pollutants in the ambient air. The NAAQS are health-based, and EPA sets two types of standards. There's primary and secondary NAAQS standards. The primary standards are designed to protect the health of sensitive populations like children, elderly, asthmatics. Secondary standards are concerned with protecting the environment, things like damage to crops, vegetation, damage to buildings, animals. The Clean Air Act wants EPA to set criteria pollutants for widespread air pollutants, and the limits, the criteria, are based on the latest available scientific information. EPA is required to periodically review the pollutant limits that it sets and make sure that they're consistent with current science. Right now, there's 6 criteria pollutants. The original 6 were particulates, sulfur dioxide, carbon monoxide, ozone, nitrogen dioxide, and hydrocarbons. In the decades since EPA has been implementing the Act, they've dropped one of those 6 pollutants. They dropped hydrocarbons, and they added one. They added lead. And within 1 year of setting a new or revised National Ambient Air Quality Standard, states and tribes submit recommendations to EPA regarding whether or not a particular area is attaining the standard. after review. And we're going to have a separate podcast about attainment and non-attainment areas and the impact of those designations. But for purposes of this podcast, basically EPA designates attainment areas and non-attainment areas for each of the national ambient air quality standards. And once we're at that stage, really it's turned over to the states. The states put together plans called state implementation plans. And with those plans, states choose individual sources within the state that have to reduce emissions, how much they develop other pollution control strategies, and those implementation plans are submitted to EPA for review. But basically, the state's goal is to meet the NAAQS. So, the NAAQS are the federal part, the federal standards that EPA sets, and the states try to meet the NAAQS using their state implementation plan, the SIP. So this is a classic example of cooperative federalism. The federal government setting standards, the states trying to implement standards. But even though state implementation plans are state focused, pollution isn't state specific. It blows around. It blows in the wind. It moves. Sometimes it moves really far, depending on the pollutant. Sometimes it doesn't move that far. But basically, air emissions in one state can impact neighboring states' ability to attain and maintain the national ambient air quality standards. And so the Clean Air Act has a mechanism to deal with that. It's called the Good Neighbor provision. It's designed to help states figure out what contributions to non-attainment are caused by emissions within their own state and what contributions are caused by emissions from other states. And other states can be required to reduce their emissions. The Good Neighbor provision is contained in Section 110A2D of the Clean Air Act. And this is one of the few times I'll refer to specific statutory language because this is the provision we're primarily talking about today. But that Good Neighbor provision requires state implementation plans to contain adequate provisions prohibiting, consistent with provisions of the subchapter, any source or other types of emissions which will contribute significantly to non-attainment or interfere with maintenance by any other state. And that's kind of the key language that tees off the rules that we're talking about today in some of the cases. Back in 2005, EPA published a final rule called the Clean Air Interstate Rule, seeking to implement the Good Neighbor provision. And after litigating that and having it sent back by the DC Circuit back in 2011, EPA tried to implement the Good Neighbor provision again through a rule called the Cross-State Air Pollution Rule, also called the Transport Rule. And Norman, who's our guest today, was one of the primary attorneys responsible for more than a decade's worth of litigation revolving implementation of the Good Neighbor provision. And actually that litigation is still ongoing today, even though Norman's retired. And so, Norman, at this point, I'll turn it over to you and see. I guess my question for you is can you tell me a little about the Clean Air Interstate Rule? Maybe walk us through some of the litigation about that rule and explain how that turned into the Transport Rule.
I think we have to go back a step, actually, because the Clean Air Interstate Rule, familiarly known as CARE, was the second time around for EPA to try to address the problem of interstate pollution. And the first was something called the Nox SIP Call. And the Good Neighbor provision had been a part of the Act for quite a while, but had not really been implemented for a long time. It was difficult. It's an odd provision. It says you upwind state have to figure out what you're contributing to a downwind state and do something about it. And states, A, didn't really have the tools to do so, and B, didn't have that big an incentive to do so, to sort of impose things on their own industries, their citizens to deal with other issues, particularly when they weren't well defined. So a big effort was started in the early 90s when EPA created a group called the Ozone Transport Assessment Group. And so it's important. One thing that's important to realize is that ozone, the criteria pollutants that Matt mentioned, the two that have been the most difficult to address have been ozone and particulate matter. ozone is the same stuff that's in the ozone layer that we need to protect when it's way up in the stratosphere. But when it's down at Earth level, it causes asthma and other health effects. But it's not something that's actually emitted out of smokestacks. It's created in the atmosphere by reactions between nitrogen oxides, which are a product of combustion, so cars, power plants, etc., and various types of organic compounds. And it's catalyzed by sunlight, so it tends to be a bigger problem in the summer. Fine particulate matter, or otherwise known as PM 2.5, which was the rulemaking that was the subject of the American trucking case, is also largely formed by precursors of nitrogen oxides and sulfur oxides. Again, products of combustion. And one of the reasons they're so difficult to address is that combustion sources are so ubiquitous. Power plants, cars, et cetera, et cetera. So early on, in the beginning, in the 90s, the focus had been on ozone. The fine particulate matter standard hadn't been articulated yet. And the original control strategy for ozone had been to deal with the organic side. But the science began, as people tried that, it was decided it wasn't working. It became clear they really had to focus on what's called the NOx side, or nitrogen oxides. So they had to control power plants. And it was also becoming clear that NOx that contributed to ozone could be transported for very long distances. So power plants in Ohio, in Minnesota, or Wisconsin could affect ozone levels in Boston and New York. And the EPA engaged in this effort in conjunction with the states, large number of states and industry groups, to do the modeling to figure out really what the patterns were, what the issue of transport was, and to try to come up with a solution. What that modeling showed was that you had this long distance transport of NOx, it's this precursor to ozone, and that that increased ozone levels in downwind states that could be hundreds of miles away. And the other thing about transport is it tends to be one direction. Winds pretty much always blow from west to east because of the rotation of the Earth and factors associated with that. So that under the sort of cooperative federalism situation, where each state has to put on sort of increasingly more stringent levels of control to try to address the pollution within the state to achieve the attainment levels, downwind states were putting on more and more controls to deal with both their own pollution, but also pollution that was being blown in across the border, whereas upwind states were to some extent getting a buy because a certain amount of the pollution that they were creating was being blown away. So EPA tried to, the idea was to use the good neighbor provision of the Act to address this disparity. So this process of this large sort of negotiation study group developed a technical basis and tried to negotiate essentially a control mechanism. It didn't work, but they couldn't come up with specifics, but there was general agreement that a cap and trade program would be the best approach. A cap and trade program is when EPA establishes a level of total emissions in some broad area and then allocates and creates essentially a bank of allowances. In other words, if EPA decides that over the northeastern United States or the northeastern third of the United States, everybody can attain, if we have 1,000 units of NOx being emitted, it then says, okay, 1,000 units is all everybody in that area can emit, and then it allocates it to the various states in the form of allowances, and then the states, generally the way this has been working, states allocate it to various sources, and then the sources can trade among themselves, this being the idea that power plants or other sources that can control things relatively cheaply can generate excess allowances that they can sell to facilities that, for one reason or another, it's either more expensive for them to do controls, or it is the plant's going to close soon and they don't want to make the investment or whatever. So
let me see if I can summarize this just to make sure I've got it. So it sounds like the big problem that we were looking at in the 1990s was ozone. And one of the predecessors to ozone was nitrogen oxide, or NOx. And NOx travels long distances, typically from west to east. And so the downwind states were installing controls, but many of the downwind states had to install controls because of emissions that were coming from upwind states, largely power plants in the middle of the country. Is that a decent summary?
That's it exactly, yes. So what EPA, because they couldn't come up with a negotiated solution, EPA turned to rulemaking and did what's called the Knox Sip Call. And what the Knox Sip Call was a rule that came out in 1998. And what EPA did there was, it, based on the modeling it had done, it determined a total of 22 states and the District in DC made what it called significant contributions to that's the statutory term, kind of the key statutory term in the Good Neighbor provision, to downwind states. And it based it on metrics involving both the sort of percentage of ozone levels they were. And this is the process that all the transport and outlined that all of the transport rules have followed. EPA establishes what they call linkages between upwind states and downwind states through modeling to show how much the upwind state contributes to ozone, and then in later rules, PM 2.5 levels in the downwind state. And then those.
Could we follow up on that a little bit? Because I've always thought that's kind of an interesting and really confusing part of this. And so, yeah, you're absolutely right. Like the statutory key revolves around you showing the problems that you're having in your state were caused by other states. And you mentioned that they figure that out through modeling. But how does that work? How do they track the air pollutants? How can you show that NOx levels in my state are caused by emissions from your state? That sounds really complicated.
It is complicated, and that's why you need supercomputer. At least in the 90s, you needed supercomputers to do it, which is why it took EPA spent in the States took several years developing these models. And at least for ozone, and when I was at Piper and Marbury, I went to a few of these OTAG sessions. They had information sessions. So I'm more familiar with the sort of more gritty details there, but ozone is basically a summer issue because the chemical reactions that cause ozone in the atmosphere are catalyzed by sunlight. So the more sunlight, the more ozone you have. So what they did was they looked at several specific days in which ozone levels had been particularly high. In other words, where they were the biggest exceedances of the attainment levels in downwind states. And so then they examined the meteorological data from those days. In other words, the same data the meteorologists use to make weather forecasts is available. Which way the winds are blowing pretty much hour to hour on any given day throughout the country, and monitored levels of NOx and ozone, and developed a computer model that sort of traced the ozone molecules from the upwind states through the known wind patterns down to the receptor states, and calculated sort of how much of the NOx and how much of the ozone was due to sources from different places by sort of tracing all these different paths through the atmosphere using the kind of basically, I think, the same kind of modeling that meteorologists use to do the weather. So that's about as deep as I ever got into it. But that's the sort of modeling that they did, and they based it on sort of specific real-time data from the most severe events.
Okay, so you mentioned the EPA did the modeling and did what you called a SIP call. So it told certain states they needed to control certain emissions. Is that
Right.
basically right?
That's right. Well, and so I guess we should define what a SIP call is. One of the provisions of the Act allows EPA to, if it decides, states do SIPs periodically, and they put together this package of controls, they send it to EPA. They do modeling to show that the package of controls they have is going to achieve attainment. And EPA then reviews the SIP submission, this package, and either approves or disapproves it. But, and if it disapproves it, and this will be important in some of the other rules, it can promulgate what's called a FIP, or a Federal Implementation Plan, where federal EPA steps in and imposes its own control scheme. But even if it approves a SIP, if you get a few years down the road and you see that it's not doing what it's supposed to be doing, you're not achieving the levels that the state said it would achieve, EPA can do a SIP call, in which basically it says, you state, your plan, even though we approved your plan, it's not working. You need to do more. And it can be just go back and start over again, or as it was in the case of the Knox Sip Call, it was in the Knox Sip Call, EPA said, you must impose this level of, you have this many allowances that for your NOx sources in your state, and you need to revise your SIP to limit that. And you have some flexibility in how you divide those up among the sources. And the mechanism for doing that were these tradable allowances, where basically the EPA gives the state, they say gives Ohio 100-ton chips of, each chip worth a ton of NOx emission, and gives Ohio 100 of them. And then Ohio can divvy it up among its power plants. And in the power plants, both within Ohio, but also within all of the other states that were subject to this SIP call, can trade them. So in other words, if you have a power plant in Ohio that for whatever reason would cost an exorbitant amount of money to retrofit, but there's one in Indiana that is either going to reduce its capacity or it has some very easy way to control emissions. The one in Indiana might, even though say it got 5 chips, it might actually reduce. You might only need to use 2 of them after it put on its controls, and then it could sell the other 3 to this plant in Ohio. That would then emit at a higher level than what it would have, if it had gone down to the 2. But still, the overall amount of NOx being emitted in the region would be reduced by the amount that was required. Does that make sense? Am I explaining that?
Yeah, no, I follow. It sounds like the cap and trade is an attempt to reach cost-effective reduction, and it gives folks an incentive, because if they can reduce it in a cost-effective way, it gives them something they can sell on the market on the back end.
Right. If they can go kind of the beyond it, then they can. So the idea was this, and this was, everybody basically liked the idea of a cap and trade program. The states, the industry, the economists, and it wasn't a completely novel idea. In Title IV of the 1990 Clean Air Act amendments had created a cap and trade program for acid rain, where Congress set up a program where power plants were given a certain number of SO2 allowances. And initially, in fact, in the first phase of that, specific power plants right in the statute, and then there was a second phase where ones were designated, which they were then allowed to trade. But all of the power plants collectively that were covered, but every power plant that was covered by the program had to hold enough allowances at the end of the year to cover its emissions. So there was a statutory precedent for implementing a cap and trade program. And it's
So I guess the question I have for you is, so it sounds like everybody agrees that cap and trade is the way that people want to take an initial run at this cross-state problem. But the statute seems to be focused on state-specific implementation plans. So how do you get from a single state implementation plan to a regional cap and trade system under the Act? How does EPA or how do the states go about doing that?
So there's a practical side and the legal side. The practical side is, basically EPA decides that the way EPA decided how many allowances to create. I mean, let's say you had 10 states, upwind states, that were going to have to put on controls, and EPA was going to create a pool of allowances to distribute them. The way EPA decided how many allowances to create, which is in an allowance in this case is one allowance is the emission of 1 ton of NOx. And the way EPA decided how many there were was it defined a specific cost level of control. In other words, it said they were going to require that emissions be brought down to the level of that could be achieved by reasonably cost-effective controls. And what they would do is they looked around and they looked at obviously the downwind areas and other areas, many of which had already put on much more significant controls than the upwind areas had, and said, okay, what are various cost levels? You can put on machine X for $500 a ton. If you put on machine Y, it'll cost you $1,000 a ton. You put on machine Z, it'll cost you $1,500 a ton. And then they used a model that, of course I'm blanking on the name of right now, but there's this big utility model that utilities use, everybody uses, that models the electric grid. And you can use it to make tweaks to things in the grid, because the electric grid works by you have a bunch of power plants and you have various regional and larger areas that decide which power plants are going to run at any given time based on cost. And at least generally the lowest cost producers will run. And there is a model that you can use that you can make tweaks to that will show that, for instance, if you put on the $500 a ton control level, what plants will run and how's that going to change, which plants run and for how long, and what level of emissions is going to result from that. And the same with the 1,000 and the same with the 1,500. So they'd run that model and adjust the cost level to the point where they would get the level of total emission reductions that they needed to reduce all the upwind states' contributions to the pollution, to the exceedances of the attainment levels in the downwind states. So then using that analysis, they would develop the pool of allowances, and then they would there's been some differences in how various rules have had different ways of allocating to the states. And some of the earlier rules, EPA actually was allocating on a facility-wide basis, but more recently they've been allocating just to states and let states figure out how to divide them up. And it has usually based on, the more generation you have, the more allowances you get, so that they're trying to be sort of roughly equitable among the different states based on how much electricity they generate or how much pollution they put. They've been different metrics for deciding how to. But basically, the way it has worked is in the Knox Sip Call, which I think is the only one of these that has not been a FIP, primarily. The Knox Sip Call, they said the states, we've decided your SIPs that we have previously approved are really not working. They're not adequate because you didn't adequately implement the good neighbor provision. So you have to redo your SIPs, and it gave them a schedule. And you have to redo your SIPs to address these downwind effects. And you have to do it by this much in each state. And they gave each state a number. And by the way, we have also created this trading program. And if you want to buy and implement that trading program, you just take these rules we've written for you and plug them into your SIP, and you can be part of this trading program. And I think pretty much every state said, okay, we'll do that. Because, as the option, as opposed to trying to come up with their own strictly in-state regulatory scheme. There might have been some exceptions, I don't remember. But basically, the state adopted the trading program.
So how did this relate to the Clean Air Interstate Rule, or lead to the Clean Air Interstate Rule?
Okay, well, this Knox Sip Call was an independent, was the first rule. It was a rule. It was litigated in a case called State of Michigan versus EPA, which I did not litigate. Jack Lipschultz also a former colleague of both of ours, still at EDS, but neither of us are no longer there, litigated along with other people. And this is where the whole issue of the use of cost levels and the use, and not even leaving this to trading, but the use of determining the amount of emission reductions based on the cost of controls and using a uniform level of controls. Because, one of the important features of this is that, states vary somewhat in how much they contribute to downwind pollutants, depending on, not only their total emissions, but where they're located. If they're farther away, they tend to emit less. Some of them affect many states, some only a few. But EPA said, in part, in order to set up a trading program, because if you were to try to divvy these up, if you give each state different rules, you couldn't have a trading program because you wouldn't have a common currency, which are these allowances. So EPA determined that the most cost-effective way to do this was this trading program, and to base it on a common level of control. Once it had established that these particular upwind states exceeded the levels it had determined constituted a significant level of contribution to downwind states. So that was litigated in the state of Michigan. And the court, in an opinion by Judge Williams, said, yeah, sure. We like economics. We like the statute doesn't specifically preclude use of costs, and it is an equitable arrangement. You're requiring states that have sort of, to some extent, gotten a free ride because their pollution blows away to share more of their burden, which was really one of the reasons we have the Federal Clean Air Act in the first place, is to avoid, some states becoming pollution havens, this kind of race to the bottom that you had with states, being sort of more industry friendly and having, very, very different tolerances for pollution levels.
So is it fair to say that basically the statute doesn't tell EPA to use costs, but EPA determined to use costs to figure out essentially the winners and the losers, who's got to pay for controls and who doesn't have to pay for controls? And
no, I wouldn't describe them as winners and losers. It used controls to try to sort of level the playing field a bit. And it didn't, the cost does not enter into which states are covered by the transport programs. That's purely based on how much the emissions from that state affect pollutant levels in downwind states. It's only in determining the level of control that has to be put on that EPA has chosen a common level. So that basically, it's the whole point really is that they're not winners and losers, is to put everybody on the same plane. In other words, everybody in one of these states has to put on. So even if your state happens to be, way out on the edge, and your pollution gets blown away the most, you have to put on the same level of controls as states that, as some power plant that happens to be closer to the downwind states. But in the aggregate, the implementing the trading program and implementing the cap will reduce these overall contributions to downwind non-attainment. And yes, the statute doesn't specifically allow it, but it doesn't prohibit it either. And Judge Williams in the Knox Sip Call case said, that's fine. It gives you flexibility. It's equitable. And that, jumping ahead a bit, that was ultimately the ruling of the Supreme Court as well in the EME Homer case when we get to that point.
Okay, so it sounds like we got a DC Circuit decision. The DC Circuit decision in the Michigan case gave a green light to the system that EPA had set up, a cap and trade system through state implementation plans. So how come we spent another 20 years litigating this?
Well, good question. Well, we'll get there. So the system worked. It got more complicated because the DC Circuit initially stayed the Knox Sip Call. And in the meantime, there is another good neighbor provision called Section 126 of the Clean Air Act Section 126 allows states and political subdivisions of states to petition EPA to make a determination that a source or a group of sources in an upwind state is not complying with the provisions of the Good Neighbor provision. In other words, that it asks EPA to specifically say, you power plant in state X are significantly contributing to non-attainment in state Y. And if EPA makes that determination, the power plant or group of power plants or whatever the sources are in the upwind state has to either shut down within, the time period, which is relatively short, slips my mind, or comply with specific regulations that EPA is going to impose on that source. And when EPA was developing in the same time frame EPA was developing the Nox SIP Call, a group of downwind states had submitted a 126 petition to EPA covered at least a number of the upwind states that were included in the Nox SIP Call. And EPA had made the determination, but then sort of tentatively made the determination of these sources, the same sources that were being covered by the Nox SIP Call, basically, were causing exceedances, but sort of didn't finalize because they said, we're going to deal with this through the Nox SIP Call. Then when the Nox SIP Call got stayed, they proceeded with imposing essentially the same type of rule directly through 126 on these same states, and with a cap and trade program. And that issue was also litigated, although with a number of issues, but not specifically. And one of the big issues was, can EPA do a 126 when it's still got this SIP call pending? And the court said yes. But I actually litigated that case, and that's a case called West Virginia versus EPA. Or excuse me, Appalachian Power. It's called Appalachian Power versus EPA from 2001. Also an opinion by Judge Williams. So anyway, we move on from the Nox SIP Call was finally affirmed by the D.C. Circuit. Because of the stay, there had to be some adjusting of deadlines and whatnot, but it was implemented. In the meantime, EPA had promulgated the fine particulate matter standard, the PM 2.5 standard. And the PM 2.5 standard, PM 2.5 is a pollutant that to some extent is emitted directly by sources, but is largely also something that's created in the atmosphere by chemical reactions involving nitrogen oxides and sulfur oxides, and generally requires somewhat more stringent levels of control over both of those pollutants to achieve attainment of the PM 2.5 standard, or the fine particulate standard, than are required either under the acid rain program or under the ozone program. So EPA decided that, again, states develop SIPs to implement this new NAAQS, the PM 2.5, or this new form of the particulate matter standard. And EPA did the same sort of analysis for PM 2.5 as well as an updated analysis for ozone, because of course years had passed and there was a lot of new data available. And again, became obvious that upwind states were contributing significant amounts of pollution to downwind states, both through PM 2.5 and to NOx, because both NOx and sulfur oxides, SO2, or sometimes called SOx, because I guess there are different forms of sulfur oxide. As you said, there are lots of acronyms here. NOx and SOx, we call them. But travel long distances. They're fairly stable, but they do engage in these reactions. So it developed a new transport rule, again using a cap and trade program, again using a common level of control, and that was the Clean Air Interstate rule. And that rule was litigated, and I was the lead litigator on that, in a case called State of North Carolina versus EPA. And that case was litigated. There were lots of issues in the case. There were a lot of issues with the way various industry and state groups had a lot of issues with the way EPA had decided to allocate allowances, because they had sort of, in addition to using a common level control, they had also made some provisions to allow states or utilities to use some Title IV allowances and convert them into allowances under the program, and they had sort of altered the amount of allowances that utilities got based on their fuel values. So, mostly all of this to the benefit of coal-fired plants as opposed to gas.
Okay. So just to summarize what we've covered. So now it sounds like we've got a new rulemaking. It's covering some different pollutants and some of the same pollutants. So we're doing nitrogen oxides, sulfur dioxide, NOx and SOx. It sounds like particulate matter is in play. All of these things react. They can impact ozone, but we've got a new rulemaking and somewhat different mechanisms, and industry is challenging the mechanisms that we're using under the new rulemaking. This is in the early 2000s. Is that right?
Yes, CARE was promulgated in 2005.
Okay.
And the initial case decision came down in 2008. So we had also there was one challenge, and this one I think was very important to the court. The state of North Carolina challenged CARE, mostly on the ground that the trading program didn't provide enough of a guarantee that their particular needs would be addressed. EPA had done modeling on that, but there wasn't anything sort of specific to the rule, and they were looking for, some tweaks or some mechanism to ensure that, all of the, for instance, that all the allowances didn't end up in the specific utilities that affected their states. So we litigated the case.
And this rule was considered pretty progressive at the time, right? As I recall, like the cap and trade and balancing all allowances, where it was something that a lot of people thought was a good idea.
Well, everybody generally did, and again, it was in essence the same process as the Knox SIP Call. It varied a lot in the details. It significantly expanded it because it was adding another pollutant, the PM 2.5, and it was it had more data. So it required more stringent levels of control and covered more states. It was also in form, it was done as a federal implementation plan. It was done as a FIP, where EPA basically said, we're disapproving your SIPs, mostly the PM 2.5 SIPs, because you haven't adequately addressed interstate transport, and we're imposing this federal plan. But if you want to, you can resubmit you can submit a new SIP. And we'll, if you submit a SIP that achieves the same levels, then we'll prove it and you can have a SIP again instead of the FIP. And some states did that and some states didn't. But it was a little different in form than it was a FIP. But yes, it's conceptually the same thing we did in the Knox SIP Call, but just expanded to additional pollutants and additional states, but with some differences in how the allowances were created. So the court, and this is an opinion by Judge Rogers, agreed with North Carolina and also agreed with a lot of the challenges to how the allowances were, found many flaws in CARE. The court agreed with North Carolina that it was inadequate because it didn't provide guarantees that, even though we had pretty good modeling to show that wasn't going to happen, that the court just said, nope, you've got to have something that makes sure that doesn't happen. And they really found objectionable a number of ways in which the allowance system had been set up. And initially, in fact, it vacated the rule. But we moved for panel rehearing. And I frankly consider this one of my high points of my career here, is moved for panel rehearing to reconsider the issue of remedy. And said, because sort of North Carolina did not want the rule to be vacated because they were actually going to gain a lot of benefit from it. And even the industry and state groups weren't all that keen on it because, in the time between when the rule was promulgated and the time the court decision came out, there'd been a lot of buying and selling of allowances. So we moved for rehearing, asking the court to simply to remand without vacature, because basically because vacature would do more harm than good. it would eliminate the significant environmental benefits that CARE was going to achieve, even as flawed as it was, and was going to cause a lot of sort of havoc in this allowance market. And the court agreed, and in what's become, I think, a somewhat important precedent for the way the court looks at least environmental cases in terms of remedy. Granted,
yeah, and I just want to follow up on that. That's one of the most interesting aspects of this case, in my mind. Remand is the court sending a rule back to EPA to reconsider certain aspects, but importantly, it leaves the rule in place while EPA is looking at it. Vacatur kind of undoes the legal impact of the rule entirely. The rule goes away, and here, and especially with a cap and trade, you get parties and, as you said, making investments into allowances and into an allowance system. And once you get enough people investing money, if you vacate a rule, it pushes all of that into limbo. It really confuses things, and so it's really interesting here that so many of the players wanted to keep the system in place, even though the DC Circuit had found that there were legal errors in what EPA did. And as a result, CARE actually effectively did a lot of work over the course of many years after the DC Circuit said that aspects of it were effectively illegal.
Yes. My EPA counsel often said CARE was the most effective unlawful rule in history. Go ahead, Matt. Sorry, I interrupted.
Oh no, that's exactly right, and really, I think really interesting is there is this rule that had an incredible impact in terms of emissions controls that everyone agrees didn't comply with the requirements of the act. But anyway, so it sounds like just to summarize where we are so far. So we have Michigan v. EPA, with the court effectively endorsing using economics as the basis for cap and trade for these cross-state issues. And then we have the Clean Air Interstate rule where EPA brought in more pollutants and brought in more states and did kind of a more comprehensive approach to this, where the court disagreed with some of the details of implementation and remanded for EPA to sort all of that out. And that, I think, takes us up to the transport rule, right?
Right. So in the transport rule, or the cross-state air pollution rule, again colloquially referred to as CASPER, I never liked that acronym, but that's what stuck. EPA had to respond to the remand in CARE, and the court's order on the granting the motion for rehearing, the petition for rehearing, basically said, we're going to remand, but this really needs to be redone and don't delay. So they had to remand it. So, but of course, time has passed. There's new data, new attainment and non-attainment determinations. So, they had to go through, again, a fairly extensive rulemaking to essentially look at the whole issue afresh, with the same approach. But, and I may point out also that in CARE, no one questioned the legality of using a single level of control, common control level based on cost, or the essence of cap and trade. They just wanted some limits on it. So, so then we come to CASPER, the transport rule, and it's to some extent, in concept, again, more the same thing, establishing upwind and downwind links. And if you ever look at a map of these links, it looks like a massive spaghetti being laid down across the eastern 2/3 of the United States, because, while the wind mostly blows west to east, it doesn't always, and it also blows north to south and southwest and northeast and all sorts of other directions. But developing the linkages between states, deciding on a level of appropriate level of control to which to base the standards, creating a, basically straight up allowance system that, you get allowance per amount of pollution regardless of the fuel or anything else, or Title IV or anything like that. And but also putting in a mechanism that limited the amount each state could exceed their allowance, their initial allowances. In other words, and I sorry, I didn't look this up, but I don't remember the exact number, but I think it was something along the lines of, states, not in so many words, but states effectively, I think, they could do cap and they could do trading, but there were going to be issues and penalties and things they had to do if they went over like 125% of their initial allocation. So that was, specifically address the issue in CARE, or the court's decision in CARE, that EPA had to do something to make sure that no downwind state somehow ended up in this sort of pollution dump because of the way allowances had been bought and sold. The rule was promulgated. There were a number of challenges, most focused on details of modeling, who was included, who wasn't, how we counted modeling. There was a challenge to the use of a single level. There were a couple of sort of legal challenges. There was one challenge was that we could not promulgate, and this was, CASPER was also done as a FIP. There were challenges to EPA's authority to issue a FIP.
And I should say, I think we maybe mentioned this earlier, but a FIP is a federal implementation plan. So right. A SIP is a state plan, but if states can't or won't meet some aspect of the federally required standards, then the federal government can come in and do their own thing, and that's the FIP part of this.
Right, and so there was sort of two variants on that argument. There was one basically saying that we couldn't issue a federal plan to a FIP telling them, they had to implement this level of control to meet the grid neighbor provision without having given the state a chance first. In other words, there was an argument that we had to go through a SIP call first before doing a FIP. And then, just sort of similar to the argument back in the 126 Appalachian Power case that said we had to do the Knox SIP call first, but somewhat different. And then there was also a challenge, and then the second sort of part along that was there was an argument that because EPA had approved CARE SIPs, SIPs that states had submitted under CARE before, or even perhaps in some cases after the court's decision, I think before the court's decision, that EPA had to go through the whole process of denying finding those SIPs to be inadequate. And so, and then another issue that was, and then there was also a challenge to the holding in state of Michigan, again challenging EPA's use of a single level of control across the entire area. In fact, they did two. There were actually two levels because some of the SO2 sources had been divided up into two groups. But so it went to the D.C. Circuit, and in an opinion by Judge Kavanaugh, the court decided two of those issues. It decided, sort of ignoring completely the decision in state of Michigan, and ignoring also pretty much the fact that this issue had not been raised in the rulemaking at all. Judge Kavanaugh decided that, joined by Judge Griffith, decided that EPA couldn't use a standard cost level, that that would constitute over control in states that were in the region, states that had a linkage but could reduce their emissions by a lower level of control. And that EPA hadn't, in putting the burden on EPA to demonstrate that hadn't happened anywhere. And then the second issue that it addressed was the one issue about the FIP, in which it said that EPA couldn't issue a FIP because it had to give states had to tell states what it had to do first, what they had to do first, and therefore it had to go through the process of issuing a SIP call before it could issue the FIP. And
let me jump into that first argument again, just to make sure I understand it. So this was Judge Kavanaugh before he became Justice Kavanaugh, yes, when he was on the D.C. Circuit, and he looked at this and said, well, if you control purely based on cost, or at least primarily based on cost, there's a chance that all of the lowest cost reductions would be focused on one particular state, effectively requiring them to over control. In other words, they would control more than they needed to based on their contribution, just because it's cheaper to control emissions there. Is that a
that was, yes, that was it. Basically he was saying that EPA had to do sort of a state by state analysis to say what level of control would achieve the good neighbor requirements in each state, and then impose that level on each state. And so there's a number of problems with that. One is, of course, that it's flatly contrary to the holding in the state of Michigan, as Judge Rogers explains in great detail in her rather biting dissent in this case. She wrote a very lengthy dissent, and if you really want to know what the state of law was at the time, you should read Judge Rogers' dissent. But it's just because that was clearly, Judge Williams talks about that uniformity is okay, and that everybody contributes a little bit, and that's actually a plus. That having equity among states was actually a plus. So, and Judge Kavanaugh just doesn't even address it at all. Doesn't address Michigan at all. He bases that whole section of the opinion on a snippet from Judge Rogers' opinion in CARE on a completely different issue, where Judge Rogers basically says, there's a sentence in that opinion about, you can't make one state bear another state's burden. But that was in relation to the way EPA had assigned allowance, the way EPA had given additional allowances to coal-fired plants, as opposed to, this kind of straight up, favoring coal plants over gas plants, which had been part of the allowance scheme in CARE. So it had nothing to do with setting a common control level. And he basically says that creates a crystal clear mandate that EPA must, in deciding the level of control, do a state-by-state analysis, which, of course, Judge Rogers, who wrote that opinion, pretty clearly says is not the case. And then the second issue, which again wasn't really raised in the rulemaking, was this issue of, well, it was a little unclear how the parties were raising it. To some extent, it sounded like the EPA had disapproved a number of SIPs. To some extent, it sounded like it was presented as a backdoor challenge to those other decisions, which were being litigated elsewhere, to the extent they were being litigated. But the court read it as sort of a general prohibition on not giving the states a chance first, which was, again, not really an issue in the rulemaking. So, and then the court vacated the rule, leaving CARE in place.
Okay, so then we're back to CARE. So we've got Michigan that endorses the economic approach. CARE, where the court says EPA did it wrong, the details, but the rule can remain in place. EPA attempts to replace CARE with the transport rule, with CASPER, which are the same rule. The cross-state air pollution rule is the transport rule, and that's the replacement for CARE. And then the transport rule is vacated, and we revert back to CARE. So CARE is still in place.
CARE was still in place, yes. So we petitioned for rehearing en banc, which was denied, and then we petitioned for cert with the Supreme Court. And the Supreme Court addressed those two issues and reversed on both of them. It basically, obviously, it's not bound by the state of Michigan the way Judge Kavanaugh should have been, but adopted essentially the same reasoning, that there was no, and this was an opinion by Justice Ginsburg. There's nothing in the statute precludes the use of cost, that it was reasonable and equitable for EPA. That it was justifiable both on the grounds of efficiency, because the use of a common level of control, which then enables the cap and trade program, which by and large the industry sources like, was the most cost efficient, and that was reasonable, and also that it was equitable, that the idea of people being subject to a common level of control to achieve attainment throughout the nation, throughout certainly this large region, was also a reasonable implementation of the statute. So the Supreme Court reversed on that ground, and it also reversed on the other ground, basically because the language of the statute is quite clear. EPA statute says once EPA disapproves a SIP, it is required to promulgate a FIP anytime within 2 years thereafter. There's no ifs, ands, or buts. There's nothing in the statute that says, but, you got to tell the state if the state isn't sure what it should do. So anyway, so the Supreme Court reversed on both grounds and sent the case back down to the DC Circuit. So at this point, CASPER is now in effect again. Although I think there was some, of course, at this point, all the deadlines in it had become sort of moot, so there was a need to adjust them. But I think it sort of remained essentially implementing CARE while we went through the next. I don't actually remember the details of when CASPER actually went back into effect. But I think CASPER went back into effect after the Supreme Court decision. But EPA did a rulemaking to adjust the deadlines to compensate for the several years in which it had been vacated. It went back to the DC Circuit to address a number of issues that hadn't been addressed in the initial decision, and the court there kind of sort of ignoring, frankly, the real gist of the Supreme Court's holding on the use of a low and level of control, but sort of seizing on a more or less boilerplate sentence about over control. Judge Kavanaugh again goes through state by state and says, well, there are these states that could, eliminate your model significant contribution at a lower cost level, and therefore you're over controlling them, which is, it's like, not seeing the forest for the twigs, because it's seizing on, literally a more or less throwaway sentence in the opinion, the Supreme Court's opinion, maybe it's not throwaway, but, a sort of almost boilerplate sentence in the Supreme Court's opinion, but ignoring, the actual logic of the Supreme Court's opinion, which is that having a common level of control across all states that make a significant contribution is a reasonable reading of the statute. And they also rejected that other argument I mentioned earlier, that EPA was precluded from issuing FIPS because it had approved CARE SIPs. And the court held, which is what we had argued, that because CARE had been invalidated, EPA's approval of the CARE SIPs was therefore invalid, and they weren't really active SIPs, even though they were being used. So, but that we still had the obligation to issue a FIP based on our EPA's earlier disapproval of the state SIPs that had justified the FIPS in CARE. So, but the court in this case remanded back to EPA to make a decision. So it decided that there were over control in 4 states for SO2 and a larger number of states for NOx. So the case was remanded back to EPA to take another look at these issues, at these particular states. But the rule did in fact go into effect. And so EPA, of course, did that. And in the meantime, the ozone NAAQS had been made more stringent. So it pretty much, all the NOx issues had to be re-examined in any event. So it basically did a whole new rulemaking to develop NOx. On the SO2 side, they called up the states involved and said, well, we can come with a new FIP, or you can just sort of opt into the trading program at the existing level. What do you want to do? And at least 3 of them opted in, because there are sort of other ramifications. It made their life easier in various ways. So interestingly enough, so at least 3 of the states for which.
So just to again do the outline. So we started back in 1990, dealing with cross-state issues that were implemented initially through CARE and then in the transport rule. And then in 2014, the Supreme Court upheld the transport rule that had previously been vacated by the DC Circuit. After being upheld, it goes back to the DC Circuit and they tweak some aspects of the implementation. And following that, we're kind of, right now in this tumbleweed of resulting issues where some states have adopted parts of the transport rule, some many aspects of it have been challenged by some states, sometimes by environmental groups, and others, other downwind states saying, upwind states aren't properly implementing the rule. But now there's this whole like nest of interrelated litigation challenging the attempts to implement the transport rule as interpreted by the DC Circuit on remand from the Supreme Court. Is that
right? That's how it came down, and then EPA did in fact promulgate a new update rule, which I did not litigate. I was sort of doing other things and also on my way to retirement, and that there was an update rule addressing all of these. It's kind of doing everything, all the ozone stuff from scratch, and I believe updating the SO2 numbers based on more current data. And that was upheld by the DC Circuit in 2019 in a case called State of Wisconsin versus EPA. Upheld except for one aspect, which is that, and there are many, many other issues in these cases, and just kind of trying to talk about the big ones, but it was remanded on the issue of that EPA had not lined up the dates that had for compliance with the CASPER update rules, emission limitations, with the attainment dates for the downwind states. This has been something of a recurring problem. But in other words, downwind states had a deadline to achieve the revised NAAQS by a certain date, and EPA was giving upwind states longer to achieve the reductions that they found that these downwind states would need to achieve in order to reach attainment. And the court said, that doesn't make any sense, and go back and do it over again. But it upheld the rule in every other respect.
Okay, right. And we talked about, I said that I would try to bring this home, the tail end of the rulemakings during the Trump administration after you had retired. But you're exactly right. In 2016, there was the update rule that tried to incorporate all of these various new interpretations and requirements. And as you can see, the fact that the NAAQS are constantly updated and the science is updated and the contributions are constantly changing, it's like these rulemaking obligations are move a lot. It's complicated. But then during the Trump administration in 2018, EPA finalized what's often called the closeout rule. It's called that because it states that EPA won't require further emissions reductions from upwind states, even though it acknowledged that some downwind states will have trouble meeting the 2008 ozone NAAQS. And that closeout rule was litigated in a case called New York v. EPA in the DC Circuit. And the DC Circuit rejected the closeout rule, finding that EPA hadn't implemented sufficiently stringent rules to deal with downstate impacts. And since that time, there have just been a whole host of mostly district court challenges by downwind states and by environmental groups challenging the failure of upwind, the alleged failure of upwind states to meet the requirements of the transport rule. And so, these cases are very much still being litigated, but, I think this history does a good job of illustrating how these rulemakings can be interconnected. We just talked through more than 2.5 decades worth of cross-state litigation, which is still ongoing, and it doesn't necessarily get less complicated. Science changes, standards change, policies change, and when you pull the string on one of these, it unravels a lot of the framework, the regulatory framework that other rules are relying on.
Right. They're all interconnected. EPA has used plans of the transport rule to constitute compliance with some other requirements under the Act. Visibility issues for one, and but yes, there's a strong relationship among the SIPs and the NAAQS as it gets revised, and the transport rules and the requirements for upwind states to address these issues just keeps going.
Well, thank you for joining me today, Norman. I want to say, one of the reasons I was really excited that you were willing to come and talk to me today was that I wanted to acknowledge and recognize like the decades worth of really complicated work that you did. I think oftentimes we get really sophisticated litigators in the United States and Department of Justice and the agencies that tackle these immensely complicated problems that take years of your life, decades of your life, and I don't think you get recognized enough. If ever I had something that was confusing me in the Clean Air Act, you were the person I would go to. You really do understand how all of this is linked together, and you've just got this amazing body of knowledge. So I'm really pleased you were able to share it with us today.
Well, thank you. It was a pleasure.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at www.americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.